If you're a law student, you know that trying to make sense of Articles 124 to 147 can feel, well, like you're lost in a maze. But what if I told you the Supreme Court's powers aren't just a long list you have to memorize? What if instead you thought of them as a toolkit, each tool with a very specific job? Today, we're going to open up that toolkit.
So, here it is, the highest court in the land. We all know it's powerful. But the real question isn't just what it decides, it's how. How does it get to hear a case for the very first time, or review what another court has already decided? Or, in some cases, just give its expert advice? That's what we're breaking down right now.
So, here's our game plan. First, we'll look at the big picture, the toolkit itself. Then we'll zoom in on the three main tools the court uses: its original, appellate, and advisory jurisdictions. And finally, we'll wrap it all up with a simple roadmap you can use.
All right, let's get into it. First things first, let's lay out our framework. Instead of getting bogged down in a huge list of constitutional articles, we're going to organize the court's powers into three main jobs, three functional categories. Trust me, this little shift in thinking is the key to making it all click.
You know that feeling when you're staring at Articles 124 to 147 in the Constitution and your eyes just glaze over? Yeah, you are definitely not alone. It is a dense section of the law. But here's the secret. Hiding inside all that complexity is a surprisingly simple structure.
And here's that structure. It really just boils down to these three main tools. You've got original jurisdiction, which is when the court is the first one to hear a case. Then you've got appellate, where it reviews a decision from a lower court. And finally, advisory, where it acts like a constitutional consultant. That's pretty much it. If you can get your head around these three, you're most of the way there.
Let's start with the first tool, original jurisdiction. Now, what's so interesting about this one is that the Supreme Court isn't acting like a referee looking back at a game that's already been played. No, it's stepping right into the ring, hearing a dispute for the very first, and often final time.
In simple terms, this is the power to hear a case from scratch. It's not an appeal. The Supreme Court is basically putting on its trial court hat, a role that we don't usually associate with the highest court in the country. The magic number here is Article 131. And this power is exclusive, meaning only the Supreme Court can handle these specific cases. So what kind of cases are we talking about? We're talking about major disputes between governments, say the center versus a state. It's an absolutely essential feature for a federal system, like India's, because you need a neutral place to settle arguments between these powerful government players.
So who gets to use this special tool? Well, it's a pretty exclusive club. It's reserved for disputes between governments. That means the government of India versus one or more states, or states fighting against each other. And here's the most important takeaway. You and I, as private citizens, we can't use Article 131. This door is closed to us.
Okay, on to tool number 2, and this is the one the Supreme Court uses all the time. It's really its main job. Let's talk about appellate jurisdiction. This is the Supreme Court in its most famous role, the final word, the ultimate court of appeal, reviewing decisions that have already worked their way up through the lower courts. Let's put these two side by side to make it super clear. On the left, original jurisdiction is the exception, the court acting like a trial court for those big federal disputes. On the right, appellate jurisdiction is the rule. This is the court's bread and butter. It's not about hearing new facts, it's about checking the work of the lower courts to see if they got the law right. But, appeals aren't all the same. The Constitution actually sets up three main pathways to get to the Supreme Court. You've got constitutional matters under Article 132, civil cases under 133, and criminal cases under 134. Each one has its own specific trigger, its own key to unlock the door. But beyond these organized lanes, there is one more incredibly powerful way to appeal. And this is it, Article 136. Just listen to this language. Notwithstanding anything, the SC may, in its discretion, grant special leave to appeal from any judgment, from any court. That incredibly wide phrasing is the source of the court's most powerful appellate tool. So you should think of the special leave petition, or SLP, under Article 136 as the toolkit's wild card. It's this massive discretionary power. If a case doesn't neatly fit into the other appeal categories, constitutional, civil, or criminal, the SLP is that last hope, that final door a person can try to knock on. All right, let's grab our third and final main tool from the kit. Now this one is really unique. It's called advisory jurisdiction, and it's where the Supreme Court basically takes off its judge's robe for a minute and puts on a consultant's hat, offering its expert legal opinion to the president. Now, the crucial thing to get here is that there's no fight. There are no two sides battling it out. There's no plaintiff, no defendant. Instead, it's the President of India who has a major question of law or fact and directly asks the Supreme Court, hey, what's your take on this?
This whole process is governed by Article 143, and it creates a really fascinating situation. The president asks for advice, the court gives it, but the president is not bound by that opinion. But, and this is a huge but, the legal reasoning laid out in that opinion is considered law under Article 141. It's binding on every other court in India. So, it's technically just advice, but it's advice that carries the full force of the law.
So, we've gone through the three main tools: original, appellate, and advisory. But there's one more thing in the toolkit I want to talk about. It isn't a specific type of jurisdiction, but it's more of an overarching power. You can think of it as a master key that works in any case the court is hearing. And that master key is Article 142. It gives the court this incredible, inherent power to do what it calls complete justice. You can think of it as a fairness power. It's there to make sure that strict rules or some procedural mistake doesn't get in the way of a just and fair outcome.
And here it is, your jurisdictional roadmap, all in one place. This table brings everything we just talked about together. You've got the exclusive power of Article 131, the different ways to appeal, including that Article 136 wildcard, the unique advisory role of 143, and the complete justice master key of 142. This is the Supreme Court's toolkit in a nutshell.
Which really brings us to this final big picture question. Now that you can see these different tools, original, appellate, and advisory, how does this specific design, this deliberate separation of powers, actually shape the rule of law in India? Because the answer to that question, well, that's where you start to understand the true power and purpose of the Supreme Court. Thanks for tuning in.